Okay, our next topic is on custodial investigation and the inquest proceeding. If you are arrested and taken into police custody and interrogated for a crime, you are under custodial investigation. Custodial investigation also includes any questioning or probe of a person invited by a law enforcement officer in connection with the offense he or she is suspected to have committed in accordance with Republic Act number 7438. Republic Act 7438 is an act defining certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting officer, detaining and investigating officer, and providing penalties for violations thereof. This law was signed by President Corazon Aquino on April 27, 1992. In short, this Republic Act serves as additional safeguards for persons who are under arrest and a support to the provisions of the Constitution as previously said in the lesson, legal basis of arrest. There are also prohibited acts under this Republic Act. One is failing to inform any person arrested, detained, or under custodial investigation of his right to remain silent and to have competent and independent counsel, preferably of his own choice. Second, failing to provide a competent and independent counsel to a person arrested, detained, or under a custodial investigation if the latter cannot afford the services of his counsel. Rights of a person under custodial investigation, responsibilities and authority of arresting officer or investigator during custodial investigation. During custodial investigation, the person under custodial investigation have the right to be assisted by the counsel of his own choice at all times. And the arresting officer or investigator has the responsibility to ensure that this is provided. The arresting officer or investigator, as the case may be, has the duty to inform the rights of the person under custodial investigation in a language known to him or the language that he or she understood. The following rights shall be reminded or shall be informed to the person under custodial investigation. One, rights to remain silent, that anything, okay, he or she may say can be used for against him or her in the court of law. The right to counsel or to choose a counsel of his own, that if he or she cannot afford one, okay, the government, okay, will provide an independent and competent counsel. And that, okay, uh, he have the right to be informed of these rights. Assuming that the person under custodial investigation, oh, okay, he did not or he does not want to give a sworn statement, the arresting officer or investigator must reduce it in writing. So it must be written stating that the person under custodial investigation refused, okay, to give a sworn statement. He must also ensure that before the person under custodial investigation sign or place, okay, his or her thumb mark, okay, if this person cannot read or write, the sworn statement shall be read and adequately explained to this person or to him or her by the counsel of his or her choice or by the assisting counsel provided by the government in the language or dialect known to him or her. The arresting officer or investigator must ensure that any extrajudicial confession or a confession made out of court and not as part of the judicial examination or investigation made by the person under custodial investigation shall be in writing. It must be signed by him in the presence of his counsel or in the absence of the counsel upon a valid waiver and in the presence of any of his or her parents, elder brothers and sisters, spouse, the municipal mayor, the municipal judge, district school supervisor, a priest, imam or a Muslim leader, or minister of the gospel as he may choose so. Failure of the arresting officer or investigator to observe the above procedures to render such extrajudicial confession, it will be inadmissible as evidence in any proceedings. During the custodial investigation, the arresting officer or investigator has the duty to allow the person under custodial investigation to be visited by or have conference with any member of the immediate family, medical doctor, priest or religious minister chosen by him or by his immediate family or by his counsel. Non-government organization accredited by the Commission on Human Rights or by any international non-government organization duly accredited by the Office of the President, spouse, fiancé, parent or child, brother or sister, grandparent or grandchild, uncle or aunt, nephew or niece, and guardian or ward. If arrested through warrantless arrest, the arrestee shall undergo a process called inquest proceedings. Inquest proceeding is the informal and summary investigation conducted by a public prosecutor, or this is what we call inquest prosecutor, for the purpose of determining whether or not the warrantless arrest is valid. Take note. So the very purpose of inquest proceeding is to determine if the warrantless arrest is valid. If the arrestee opt for preliminary investigation or refuse to execute the required waiver. Okay, take note. If he he doesn't like to undergo for a preliminary investigation or he refused to execute a waiver or the required waiver, so the investigator must proceed with the uh, inquest by submitting the arrestee before the inquest prosecutor, along with the sworn statements or affidavits of the complainant and his witnesses, if any, and other supporting evidence or documents. The presence of the arrestee is required during the inquest proceedings, except if the arrestee is in the hospital or he or she is detained in a place under maximum security, if his presence will involve maximum security risk, or if his presence is not feasible by reason of age, health, sex, and other similar factors. The inquest proceedings commence when the inquest prosecutor received from the law enforcement authorities the affidavit of arrest, statements of the complainants, affidavits of the witnesses, if any, and other supporting evidence gathered by law enforcement authorities in the course of their investigation of the criminal incident wherein this particular person is involved. During the inquest prosecutor, to the extent possible, should have the documents submitted to be subscribed and sworn before him by the arresting officer, complainants, and the affiants. So we will go to the documents to be submitted or needed in filing a case, or particularly this can be used in the case folder of the different cases. For murder, homicide, and parricide, okay, these are the things that must be submitted. The certified true or machine copy of the certificate of death of the victim and the necropsy report. If you say necropsy report, this refers to the commentary undertaken after the autopsy has been completed. So this includes also the certificate of postmortem examination if readily available. For prostrated or attempted homicide, murder, parricide, and physical injuries cases, okay, there are three, okay, documents to be submitted or needed to submit. Medical certificate of the complaining witness showing the nature or extent of the injury. Certification or statement as to the duration of the treatment or medical attendance. And the certificate or statement as to the duration of incapacity to work. For the violations of the Dangerous Drugs Law or the Republic Act 6425 or Dangerous Drugs Act of 1972 as amended by Republic Act 9165 or the Comprehensive Dangerous Drugs Act of 2002. Here are the documents to be submitted. One, the chemistry report or the certificate of laboratory examination duly signed by the forensic chemist or other duly authorized officer. Second, the machine copy or the photograph of the Vivas money, the inventory or the list of the property seized, and the affidavit of the poser buyer or the arresting officer. For theft and robbery cases, violation of the Anti-Piracy Law and Anti-Highway Robbery Law of 1974 or the Presidential Decree number 532 and violation of the Anti-Fencing Law, Presidential Decree 1612. So here are the documents to be submitted. List or inventory of the articles and items subject of the offense and statement of their respective value. For rape, seduction, and forcible abduction with rape cases, the documents to be submitted are the following: medical legal report or the living case report if the victim submitted herself for medical or physical examination, and statement of the victim or complainant. Violation of the Anti-Carnapping Law or the Republic Act 6539 or Anti-Carnapping Act of 1972 as amended by Republic Act 10883 or otherwise known as the new Anti-Carnapping Act. The documents to be submitted are the following: machine copy of the certificate of motor vehicle registration, machine copy of the current official receipt of payment of the registration fees of the subject motor vehicle, and other evidence of the ownership. Violation of the Anti-Cattle Wrestling Law or the Presidential Decree 533. Okay, documents to be submitted are the following: machine copy of the cattle certificate of registration, and picture of the cattle if readily available. For violation of illegal gambling law or the PD 1602, the documents to be submitted are the following: gambling paraphernalia and cash money if any. For illegal possession of firearms and explosive, PD 1866, codifying the laws on illegal or unlawful possession or manufacture, dealing in acquisition or disposition of firearms, ammunition, or explosive, or instruments used in the manufacture of firearms, ammunition, explosives, and imposing steeper penalties for certain violation thereof, and for relevant purposes as amended by Republic Act number 9516, codifying the laws on illegal or unlawful possession, manufacture, dealing in acquisition, or disposition of firearms, ammunition, or explosive or instruments used in the manufacture of firearms, ammunition, or explosives, and imposing stiffer penalties for certain violations thereof, and for other relevant purposes, and as amended further by Republic Act number 10591, entitled Comprehensive Firearms and Ammunition Regulation Act. So here are the documents to be submitted. The chemistry report duly signed by the forensic chemist and photograph of the explosive or explosives if readily available, and certification from the Firearms and Explosives Office, Civil Security Group of the PNP. Violation of the Fisheries Law or the Republic Act 8550, or known as the Philippine Fisheries Code as amended by Republic Act 10654, an act to prevent, deter, and eliminate illegal, unreported, and unregulated fishing. So here are the documents to be submitted. The photograph of the confiscated fish, if readily available, certification of the Bureau of Fisheries and Aquatic Resources, and paraphernalia and equipment used in illegal fishing. For violation of the Forestry Law or the Presidential Decree 705, the documents to be submitted are the following: scale sheets containing the volume and species of the forest products confiscated, number of pieces, and other important details such as estimated value of the products confiscated, the certification of the Department of Environment and Natural Resources or the Bureau of Forest Management, and the seizure receipt. The inquest shall proceed unless the arrested person opts or make a choice for a preliminary investigation by executing the required waiver of rights under Article 125 of the Revised Penal Code. Request for preliminary investigation and waiver of Article 125 of the Revised Penal Code. So take note, under Rule 112, Section 7 of the Revised Rules on Criminal Procedure, it states that when a person is lawfully arrested without warrant involving an offense which requires a preliminary investigation, where the offense is at least 4 years, 2 months, and 1 day, the complaint or information may be filed by a prosecutor without need of a preliminary investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complainant may be filed by the offended party or a peace officer directly with the proper court based on the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed by the prosecutor, the person arrested may ask for a preliminary investigation, but he or she must sign a waiver of the provision of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Under Article 125, it provides penalties against the public officer or employee who shall delay in the delivery of the detained persons to the proper judicial authorities within the period of 12 hours, 18 hours, or 36 hours, depending on the gravity of the offense. Notwithstanding the waiver, Okay, the person arrested may apply for bail and the investigation must be terminated within 15 days from its inception. Thank you for watching. I hope to see you in the next video. And for your questions, you may contact me on our FB page.